All right. Good afternoon. It is now 12:38. We have had some technical difficulties with the statutory requirement for live streaming. That has been resolved. We have kept the Zoom cameras on the entire time, as well as the microphones, so all who are on could see us. My name is Jonathan Kwan. I'm the chairman of the Criminal Law and Procedure Review Commission. We are here for a plenary meeting of the commission. It is now 12:38 p.m. on May 29th, and this meeting is now called to order. I note for the record, we are in person in the Judge Joaquin B. Manigusan Senior Memorial Courtroom in the Judicial Center. We are on Zoom for those members who are not able to attend in person, and we are now finally on live on the Judiciary's YouTube channel. As this meeting is being recorded to avoid background noise, I ask the members appearing by Zoom, please mute yourselves unless you are speaking. And if you are here in person, please wait until we position a microphone before you speak. Please turn to the next slide. Agenda item 2, due notice. I note for the record that due notice of today's meeting has been provided pursuant to the requirements of the open government law. Copies of the newspaper notices have been included and were included in your packets. At this point, we will now move to item 3, quorum. We'll start with a roll call. Members who are here, when your name is called, please state present and the location you are appearing from. May I ask our CLRC Administrative Assistant, Ms. Lisa Vanis, please call the roll.
Honorable Jonathan R. Kwan.
Present. Judiciary of Guam. Again.
Honorable Maria T. Senzon.
Present from off island at the All Rise Conference in Florida.
Honorable Anita A. Sokola.
Next.
Attorney William Bucky Brennan.
Present from my office in Agana.
DOC Director Fred Berdalio.
Present, Judiciary of Guam, Agana.
Chief of Police Stephen Ignacio or designee Sergeant Michael Elliott.
Michael Elliott is present and again to winning Guam in my vehicle.
Attorney Joseph B. McDonald.
Present from Anaheim, California.
Attorney F. Randall Cunliffe. Mr. Monty McDowell.
Present. Judiciary of Guam.
Public Defender Designee Attorney John Morrison.
Present, Judiciary of Guam, Agana.
Attorney General Designee AAG Emily Reese.
Present in the Judiciary of Guam and Agana.
Attorney Michael Phillips. Miss Valerie Regis. Attorney Christine Tenorio.
Present in my office in Agana, Guam.
Attorney Attorney Philip Tedinko. Ex officio member CLRC Executive Director Serge Kenga.
Present at the Judiciary of Guam.
Compiler of laws Jerry Cepeda.
Present at the Judiciary of Guam.
Call Judge Sokola again.
Honorable Anita A. Sokola.
All right. At this point, how many do we have?
Mr. Chairman, there are 10 commission members present.
Thank you. I entertain Mr. Executive Director, you concur with the quorum.
Yes, I confirm our quorum.
And we can conduct this as a commission's meeting. At this point, let us proceed to item 4. Minutes. We have the minutes of February 6, 2025 plenary meeting, which we tabled at our last meeting, and the minutes of April 10, 2025 plenary meeting. These minutes were provided in a meeting packet for members' review. May I have a motion to approve both minutes? I move that they be approved as written. Is there a second?
A second.
Any opposed? There being none, the motion carries and the meetings and the minutes are approved. Let us proceed to item 5, old business. Please put up the next slide. May I ask the Executive Director to provide a status and update report?
Thank you, Mr. Chairman. I have just a few informational items to report. I'd like everyone to please welcome our newest voting member of the CLRC, Assistant Attorney General Emily Reese, who is a new designee of Attorney General Douglas Moylan. On behalf of the commission, I'd like to thank the former designee, Nathan Tennyson, for his work on the commission and wish him well in his new endeavors. The 2025 first quarter report of the commission was issued a few weeks ago and is available on the CLRC webpage. I encourage anyone who is on our meeting today to look at that if you so desire. As an update of our review of Title IX, of the 46 chapters in Title IX, 24 chapters have been completely reviewed and are to be presented in the interim report to be discussed today. 14 chapters are currently in review and 8 chapters are pending review. We will review Title VIII upon completion of Title IX. That's all I have to report, Mr. Chair.
Thank you. All right, if you could turn to the next slide. Continuing with the next item under old business, we have the Criminal Procedure Subcommission's continued discussion of a chapter previously presented. Mr. Executive Director, you may proceed.
Thank you, Mr. Chair. I am presenting this as an ex-official member of the Criminal Procedure Subcommission and with the approval of our subcommission chairperson, Judge Anita Sokola. Next slide, please. For clarity, this is a continuation of the presentation I made at our last plenary meeting in April on our subcommission's recommendations for Chapter 52, which is entitled Perjury and Offense Against the Integrity of Official Proceedings. In our previous presentation, our recommendations on Section 52.10E were inadvertently omitted from our PowerPoint slides and were not discussed. I apologize to everyone for this oversight. And today I will present only on this subsection 52.10E. Now, to begin with, Section 52.10, I'm sorry, could you go back to the last slide? 52.10 is a definition section in Chapter 52. In this slide, the recommendations shown here in red were presented and approved by the commission at the last plenary meeting. However, as you can see highlighted, subsection E was unintentionally left off the slide, and I simply failed to present it. Next slide, please. Here you see subsection 52.10E in its present state, which states, statement means any non-trivial representation, but a representation of opinion, belief, or other state of mind is a statement only if it clearly relates to a state of mind apart from or in addition to the facts which it otherwise represents. And as shown here, we are recommending the deletion of the term non-trivial, the addition of the word includes, and deletion of the phrase is a statement. Our recommendations are intended to bring this definition of statement back closer to the definition of statement in the source model penal code section 241.0 sub 2. Which is shown here in our comment. We believe that the deletion of non-trivial is the most substantive amendment we recommend. The other recommendations are more to follow the form of the MPC section for consistency. Unfortunately, although we researched this ad nauseum, we're not able to determine why the drafters inserted non-trivial. The term is not in the MPC section or in the old Guam Penal Code section cited, or in the New Jersey statute that are cited in the source comments to this section. Next slide, please. We also believe that the term non-trivial may create a potential conflict with the term statement as it is used in sections 52.15 and 52.20 as shown here. In 52.15, a person is guilty of perjury if the false statement is material and which he does not believe to be true. In 52.20, it states only a false statement which he does not believe to be true. Section 52.20 does not mention materiality, so we think non-trivial creates a conflict, especially with 52.20. We believe that the meaning of non-trivial might also be problematic. Does non-trivial go to materiality? There's no definition of non-trivial statement in section 52(10), but there is a definition of material statement. We're not sure if non-trivial is an additional element that might have to be proven. But it is not in the MPC, and it seems to be at least unnecessary and at most problematic. So these are the changes to subsection 52(10)(E), which are for consistency with the model penal code that the Criminal Procedure Subcommission recommends. We welcome any questions and comments, and thank you, Mr. Chairman and members of the commission.
Thank you, Attorney Kanga. Is there any discussion on this subsection? It seems to be just a single fix on the initial statute. On a bulk of statutes that were approved the last round. So this is just that one that it was omitted.
That's correct.
Is there any discussion on this? There being none, is there a motion to approve? I move that be approved.
A second.
Is there any objection to this being moved to the final read on? There being none, it carries. Thank you.
Thank you, Mr. Chair, members of the commission.
Let's move to item 6. Okay, at this point now, we're turning the commission's attention over to the next item of the agenda, which is the CLRC interim report for consideration and vote. This is the report itself. It's not bound yet that we're proposing to be approved, and then we disseminate it to the legislature, to the governor, and to the chief justice as well. Well, Mr. Executive Director, go ahead.
Thank you, Mr. Chairman. Next slide, please, Chair. For the record, I will provide background information on the interim report. The information I present here is included in the packet and within the report itself. The interim report was submitted to the members of the CLRC on May 15 to provide adequate time for your review, and is included in the packet sent to all members prior to this plenary meeting. The packet and the draft interim report are posted on the CLRC webpage. Because it is voluminous, the interim report is not presented in these slides. We can, however, pull up the PDF interim report if there are any discussions on the recommendations it contains. The draft interim report contains the commission's recommendations that have been approved through the first phase review process. These recommendations are now presented to the plenary commission for its final review and approval. Only the chapters that have been completely reviewed and approved are to be included in the final interim report. Chapters pending review or approval will be presented at a later time. The interim report consists of a narrative explaining the process of review by our subcommissions. The report also contains as attachments our enabling legislation, a section-by-section table of recommendations, and our actual recommendations in black line format showing deleted or added language. CLRC comments for each recommendation are included. Again, for the record, I'd like to summarize the review process contained in the interim report. So the commission follows the guidelines for review that are set forth in our enabling law, Public Law 36-119. The primary work of the members occurs at the subcommission level during working sessions called by their chairpersons. Guam's criminal codes are primarily based on the model penal code. So members base their review on the model penal code and other MPC jurisdictions, particularly jurisdictions cited in the source comments of the Guam statutes. In addition, review is sometimes based on U.S. jurisdictions with recently reformed or revised criminal codes, such as Hawaii and the District of Columbia. Members identify provisions that are archaic or unused, unconstitutional or inorganic, that contain outdated language, among other issues, and propose recommendations to resolve such issues. Members may recommend amendments, repeals, or recommend no change. It bears emphasizing that our members are current and former prosecutors and public defenders, judges and former judges, and lay people with many, many decades of experience with Guam's criminal laws. The recommendations that are presented today have gone through the first phase in initial review and approval process. Recommendations that are not approved in the first phase are subject to further discussion and resolution of issues. They are then presented again to the plenary commission for approval. The recommendations that have been approved in this first phase are presented here for the plenary commission's final review and approval. Attachment 1 to this interim report is a copy of the Commission's Enabling Act, Public Law 36-119, which is codified at 1 Guam Code Annotated Chapter 25. Attachment to the interim report is a table, a detailed table tracking the recommendations of the Commission by chapter and section by section. Attachment 3 to the interim report presents the actual approved recommendations in black line format. Recommended amendments, adding new language are underlined, and amendments deleting existing language are struck through. Commission comments are included to explain the recommendations. Under our enabling law, Public Law 36-119, the CLRC must approve its final recommendations by at least 8 votes. If the interim report is approved, it will be finalized and submitted to the legislature. Thank you, Mr. Chairman and members of the Commission.
All right, this point, ladies and gentlemen. This is a fairly landmark vote we're taking right now. Just so that there's clarity. This is particularly to authorize the removal of these statutes that we've been working on thus far for the past 2 years out of the final reading file. And then transmitting it to the legislature, the governor, and the chief justice. We are more than, I think, 75% through. Not including the statutes that are pending review still by the subcommissions. I will now entertain a motion to approve this item for discussion purposes. Is there a motion to begin the discussion?
So move.
Second?
I'll second.
Okay. Is there anyone wanting to say anything or raise any issues or begin discussions on this? If not, that's fine.
No. No.
The reason for this, from my standpoint, is we've worked to the point where we're in we've gotten a certain way through. It's a law that was generated by now Speaker Boss, and we want to make sure that all the work that's been done is going to come to fruition.
Yep.
That we haven't wasted our time. And this is not the legislature that passed a law that got us into this, what we're doing. It was the previous legislature, but we feel that the legislature will carry through and will support what we've done, but we don't know that for a fact. So if they approve and enact what we've written, I think we're going to feel like we're really on good footing, and we can go through it to the other 25 to 30%, and then do the intent of the original law, and feel good about it, because I'm one of the few people that are not a legal eagle. I'm not an attorney, and but it's inspirational that the attorneys of Guam have given their time basically freely. I realize there's a stipend, but we've really, from utilizing the attorneys of Guam for my own business and personal use, we've got some brilliant minds here in Guam that have worked on this, and I'm very proud of what they've come up with, and I think the legislature, if they don't support it, is very short-sighted. So this is the time to see. I think they'd be very proud and pleased with what the package has come through. I just hope I'm right.
Thank you, Mr. McDowell. Anybody have any other discussions or comments?
I have a comment, Mr. Chair. This is Bucky from the Areola firm.
Please.
I wonder if it might be prudent to, I don't want to say amend the motion, but tag along to the motion, because I anticipate the legislature may have one or more public hearings concerning our work product. And it has been raised in the past, I believe, by Judge Senzon, that as sitting judicial officers, there could be some issues with our judicial officer members speaking in a public forum in favor of, our work product. I wonder if we shouldn't delegate to the executive director and those non-judicial officer subcommittee chairs the ability to advocate or, appear at said hearings on behalf of the commission in lieu of the chairperson as a judicial officer. That would be my suggestion and my, I guess, tag along to the motion.
Good point. But I'd like to get the first part out first before we get to that. If we can get it through, then we can address that at a later point, but that's actually an excellent point. So without confusing anything, I appreciate the comments. Let's try to get this through first. Any other comments? I want to point out, I'd like to say something. So in reference to Mr. McDowell's statement, I was called to a meeting with the oversight chair, Senator Tadwood, as well as the speaker. Met with both. They absolutely want this. They are chomping at the bit, if you will, to look at our work, to examine it, and to move forward. So they are cognizant that this commission has done amazing work, and they would like to get their hands on it so that they can make something of it. So in line with what you were saying, they want to go forward. They're asking for the product. So that's why we're here today.
Well, it's good to hear you say that because we came down here to meet with them a couple of times and they felt chill, which was a little bit of a kick in the teeth. I felt at the time. They said, well, they're having a hearing over there. So I personally went over to the hearing and there was 2 senators having a hearing. So we're with the other 13. Yeah, so this is really going to be so, and those are 2 very important members of this particular legislature. That is speaks volumes. So as they go, they're leaders, and hopefully they bring the rest with them and just proceed on.
They both expressed their appreciation, and they both expressed their thankfulness that we're doing this work. So with that, if there are no further comments, I'd like to entertain a motion if somebody would make the motion to approve the interim report and
So
transmit it.
So
Is there a second?
I'll second.
Now, because this is a landmark vote, I'm gonna request that Ms. Ibanez call out each voting member who is present by name. And when your name is called, please vote yes to approve or no to disapprove. Go ahead, then.
Before we begin, I want to note that Judge Sakota has been online the whole time. I think
That's right.
Okay, Judge Secola's here.
Just note that for the record, that she's here and I guess she'll be voting.
Yeah, she's been on. We've noticed her name on the screen. Perhaps just an audio issue. So please make sure that she's.
Thank you.
Okay, go ahead and make the vote call.
Okay, Honorable Maria T. Senzon.
Mr. Chairman, to the extent and consistent with what Mr. Brennan did express and with what I had expressed previously as well, and some of the concerns of that I did have, I will abstain from voting on this issue.
That's fine. Thank you. Abstain.
Thank you.
Cola.
Yes.
Thank you.
Attorney William Bucky Brennan.
Yes.
Director Fred Verdalio.
Yes.
Designee Sergeant Michael Elliott.
Yes.
Attorney Joseph McDonald.
Yes.
Mr. Monty McDowell.
yes,
Designee Attorney John Morrison.
Yes.
AG Emily Reese.
Yes.
Christine Tenorio.
Yes.
Honorable Jonathan Arquan.
Before I make my vote, I want to point out that I am not a subcommission chair. I have specifically removed myself from active work at the subcommission level, which is the discussions and back and forth arguments in reference to the substantive statutes themselves. My role as executive director is simply one of organizer, logistical provider, and the one who's pushing the parts to get this done. So I'm primarily an administrative agent for the commission. I'm not a substantive agent. So I do not perceive there's the same complications for Judge Senzon do not exist for me. To this point, in my role as the chairman, which is purely administrative in this regard, I am voting yes.
Okay, Mr. Chairman, I confirm 10 yes votes and 1 abstain.
Thank you. I want to thank you all for your vote today. This is a very important landmark. Mr. Executive Director, please go ahead.
I'll confirm that we have enough votes to pass to approve the interim report.
All right, thank you.
I would just like to say, if I can, that
Please.
a lot of work has gone into this, and I am truly indebted to every person, every member, every ex officio member who has contributed to the review of the criminal laws that we've looked at so far. I knew going in that this would be one of the most difficult undertakings I've ever had to do in my career as an attorney in Guam. But with the help and support of the members who have contributed the work, I think the work product I'm very proud of each and everyone who has contributed. I think it's good work product. It's solid. It's based on diligent review of the authorities that are applicable. I think it's based on the decades of practical and personal experience that each of our members have had. And the product that comes out of this, I think, will do exactly what our enabling legislation intended, which is to update and modernize the criminal laws of Guam. We've got a lot of work to do, but I'm very confident that we'll get the job done eventually.
All right, a written resolution memorializing the CLRC's approval of the interim report will follow. The interim report will be finalized for submission to the legislature, the governor, and the chief justice within 2 weeks. I'd like to thank all the members, the ex officio members, as well as the staff, those who have worked on this in the past that have moved on, and the current staff we have, Mr. Banas, as well as my chamber staff, as well as the executive directors and the compiler of laws and her staff that have put countless hours, a lot of them unpaid and after hours to do this. I want to thank you all, especially the members who donated their time. The $50 that is paid is nothing compared to the expertise and work you have provided. Thank you all. At this point, the members of the commission will continue to review the rest of 9 and 8. And hopefully we will finish our task and mandate. That being said, our next meeting.
I think, don't we have something with Bucky that we need to resolve? We have to go back with what he said.
Right, so his recommendation is that no judicial officer will testify at the or provide positive or negative testimony as to the recommendations made in this report. As that's why I indicated in my statement that I'm strictly administrative, so I'm just pushing the product forward. Judge Senzon has a more difficult position because she's actually in the mix of the argument.
So when that's presented, if they have an oversight hearing on it,
Right.
who is going to represent this group?
It will probably be the executive director.
And any other member of the
Wish to
commission that
appear.
would like to appear and provide testimony on it. But I think that especially with the role of our active judges, they have to be cognizant of their own ethical duties and will make the decision that is right for them, whether they can or should appear if they are called to. They can take it up at that point. I don't know if we need to formalize that
Right. At this time.
at this time, right?
Judge Senzon is requested to speak. Judge Senzon, go ahead.
Thank you, Mr. Chair. Just to the extent that of my personal participation as a subcommittee chair or a subcommission chair for the DOCO subcommission, in the interest of and in the administration of justice, I did undertake the very hefty role of replacing retired Judge Barrett Anderson, acknowledging, of course, that there could be some potential issues with to testify about what my subcommission did undertake, how we met, things of that nature, and the rationale behind the changes that were or the amendments that were made. And I think that we covered a lot of that information during the meetings and when our compiler did cover on my behalf. So I just, in an abundance of caution, did not want to vote on the entirety of the presentation because I only worked on the specific laws regarding to the Uniform Drug Code and other crimes, and not expressing any opinion about any of the other provisions that were worked on by the other subcommissions. And again, I think that my role does comply with and comport with the requirements of the model judicial code of conduct, and is in furtherance of the administration of justice. So any questions in terms of whether or not I would be permitted to, or if it is appropriate for me to even present any testimony before the legislature, I respectfully request that I reserve on that particular question.
Absolutely. Thank you, Judge. In reference to Mr. Brennan, Attorney Brennan's recommendation and request, at the time after this is transmitted, and if there is a public hearing, Mr. Brennan's suggestion will be taken up at that time to decide who is going to proceed forward and whether the two judges, myself and Judge Sanzon, can proceed. So we will address Mr. Brennan's very important issue. That being said, the next plenary meeting is scheduled for Thursday, July 31st, 2025 at noon. All right. Thank you. In reference to item agenda number 7, there's no communications to present. And item number 8, is there any comments from anyone?
I just think that once they hear it, or if they want to hear it, this can be tough to decide. You can't put enough of us in a room to answer every question they might have. Because everything was done by a group of 4.
Yep.
For example, in each committee. It's a lot easier if you represent us.
Right.
And then say, well, okay, you want to talk about these items, I'll get somebody from each committee and I'll bring them back for a second hearing. You know, or something like that. That we could fill the whole hearing hall.
We'll let the legislature wrestle with that tiger.
Hopefully they don't ask anything. Go through it and it makes perfect sense.
All right. Any other comments? There being none. Thank you all. May I have a motion to adjourn?
I move we adjourn.
Is there a second?
I second it.
Any objection? There being none, thank you all for your work today. Sorry for the delay. Thank you all. Safe travels, everyone. I'll find. Thank you. It's gonna go over now.
Emily, pleasure.